The evolution of EEO law has happened gradually over time in a long and winding road toward the goal of equal employment opportunity. Each act passed has laid the groundwork for EEO law and policy today. Let's walk through some of the groundbreaking laws that form the foundation from which EEO investigators do their work. Before the founding of the EEOC in 1964, the Equal Pay Act of 1963 was signed into law. The Equal Pay Act is a labor law that prohibits gender-based wage discrimination in the United States. Signed by President Kennedy in 1963 as an amendment to the Fair Labor Standards Act, the law mandates equal pay for equal work by forbidding employers for paying men and women different wages or benefits for doing jobs that require the same skills and responsibilities. The bill was among the first laws in American history aimed at reducing gender discrimination in the workplace. The Equal Pay Act was an effort to correct a centuries-old problem of gender-based wage discrimination. Women made up a quarter of the American workforce by the early 20th century, but they were traditionally paid far less than men, even in cases where they performed the same job. In some states, female workers were also forced to contend with laws that restricted their working hours or prohibited them from working at night. In its final form, the Equal Pay Act mandates that employers cannot award unequal wages or benefits to men and women working jobs that require equal skill, effort, and responsibility, and which are performed under similar working conditions. Under the regulations of the Equal Pay Act, employees who believe they're being discriminated against can either file a complaint with the Equal Employment Opportunity Commission or directly sue their employer in court. Combined with increased education and career opportunities for women, these regulations have been credited with helping to narrow the gender wage gap in the United States. Notably, the Lilly Ledbetter Fair Pay Act, signed into law in 2009 by President Barack Obama, required employers to redouble their efforts to ensure that their pay practices are non-discriminatory and to make certain that they keep the records needed to prove the fairness of pay decisions. This act was initiated in the name of Lilly Ledbetter, a woman who for 10 years fought to close the gap between women's and men's wages, sparring with the Supreme Court and lobbying Capitol Hill in an historic discrimination case against Goodyear Tire and Rubber Company, where she worked and learned she was making thousands less per year than her male counterparts.
I went into work as I always did, an hour to an hour and a half early, and to get my mail, to check my email. I looked at the mail and immediately fell out a rough, torn piece of paper, about a quarter of a sheet of 8.5 by 11 paper. 4 first names, Lily, and 3 men. And when I looked and saw how much those men were making, base pay only, just base pay, I just felt so degraded. I don't think I've ever had a lower point. Immediately, my mind started calculating overtime, because overtime was a big, it was a big motivator. I had children in college. We had a mortgage to pay. We had car payments. We had the usual expense that families have, and it was so hard to make ends meet. But then to stand there and look at those numbers and just think back how hard it'd been on my family when it was totally unnecessary. And I did not see how I could muster up enough of dignity to get through a 12-hour shift. I finally walked around a while and went into the ladies' lounge and tried to talk to myself and get my courage up, knowing I had to get through the shift. I really wanted to take my bag and go home. I really just wanted to run away and hide. But I couldn't do that. I couldn't. And I had to stay and face it. I got home the next morning. I explained to my husband what I had learned. And I said, unless you object, I want to file a charge with the Equal Employment Commission in Birmingham, Alabama. If I started it, I would be in it for the long haul. I wouldn't be a quitter. And he said, what time do you want to leave?
Ledbetter won a jury verdict of more than $3 million after having filed a gender pay discrimination suit in federal court, but the U.S. Supreme Court later overturned the lower court's ruling. It was this Supreme Court ruling that resulted in the infamous and scathing dissent written by Ruth Bader Ginsburg, in which she noted her disagreement with the all-male 5-4 majority decision, and she called upon Congress to act where the court had not. Despite her defeat, Ledbetter continued her fight until the Supreme Court decision was nullified when President Obama, on January 29, 2009, signed into law the first new law of his administration, the Lilly Ledbetter Fair Pay Act. Ledbetter will never receive restitution from Goodyear, but she said, "I'll be happy if the last thing they say about me after I die is that I made a difference." Despite these legal gains, today, studies show that women are still paid less than men on average. Recently, pay equity has again been thrust under a glaring media spotlight. The Me Too movement of 2018, which began as an outing of sexual harassment and sexual assault, cascaded into analysis of gender inequality in the workplace in 2019, encompassing not only pay inequity, but also barriers to advancement and representation of women in leadership. In addition, several high-profile class action lawsuits have made pay equity a hot topic in executive boardrooms across the country. Estimates vary, but according to a pay scale analysis, in 2020, women make only 81 cents for every dollar a man makes. Current day implications in pay inequality persist. The coronavirus pandemic of 2020 has forced a large portion of the population to work remotely, with layoffs on the horizon for some occupations and industries. Women have a higher risk of suffering greater penalties in earnings as a result. Women are also more likely to have to take time off work or even resign their positions to care for children who are no longer in school, as well as other family members. As an investigator or counselor, you may be given EEO complaints pertaining to this issue. Let us think for a moment about the significance of this law and how it might impact the work of an EEO investigator or counselor. Remember, the law mandates equal pay for equal work by forbidding employers from paying men and women different wages or benefits for doing jobs that require the same skills and responsibilities. The law allows for pay differentials when individuals are evaluated based on criteria such as seniority, production levels, and merit. These definitions are open to interpretation. When conducting an EEO investigation regarding an equal pay claim, an EEO investigator would therefore want to provide relevant facts and documentation that show the standards of proof, defense, and pretext argument. An investigator would document details of the complainant's position, their salary and position title currently, and years prior to the case being filed, and obtain the same documentation for comparators. They would collect performance ratings, any classification analysis, and documentation supporting the agency's defense, such as documentation of seniority system, merit system, incentives, or any other documentation explaining differences in pay. The investigator will ask complainants about their duties and responsibilities, their skills and environmental working conditions, their degree of responsibility and accountability. They would inquire about documentation that would allow a trier of fact to determine whether the complainant did substantially equal work but received less pay.
This is the story of Bruce Jones, who walked in a shadow of hate and suspicion. the shadow of what he was because of his background, over which he had no control. This is also the story of the people who knew Bruce, or thought they did. There were many of these people, and they were different from each other in many ways.
I don't know why they let people like him go to our school anyway. And I'm not the only one. My folks don't like it a bit.
Advancing 1 year in our lifetime brings us to 1964, when the landmark Civil Rights Act was signed into law by then President Lyndon B. Johnson, following the assassination of President John F. Kennedy. This act is considered the most important civil rights legislation since Reconstruction in 1865. It included a section referred to as Title VII, which prohibited employment discrimination. This effectively ended the application of Jim Crow laws that was previously upheld by the Supreme Court in Plessy versus Ferguson, stating that separate but equal was constitutional. This law stipulated that it was against the law to discriminate based on race, color, gender, religion, national origin, and forbade retaliation. The law covered all government and private sector employees employing at least 15 employees, employment agencies, and unions with at least 15 members or which operating hiring halls. Title VII is the section of the Federal Civil Rights Act that prohibits employment discrimination based on race, color, national origin, sex, and religion in any aspect of employment. These are called protected characteristics and are referred to as protected classes. Nearly all employers are covered by Title VII, including public and private employers with at least 15 employees. Title VII also created the Equal Employment Opportunity Commission to help enforce the law. On April 4, 2017, the Seventh Circuit Court of Appeals ruled the Civil Rights Act prohibits workplace discrimination against LGBT employees after Kimberly Hiverly sued Ivy Tech Community College for violating Title VII of the Act by denying her employment. The Age Discrimination in Employment Act of 1967, the ADEA, was signed into law by President Lyndon B. Johnson. Congress created the legislation to promote the employment of older persons based on their ability rather than age, and to prohibit arbitrary age discrimination in employment. Following on the heels of Title VII of the Civil Rights Act of 1964, the ADEA prevents age discrimination and provides equal employment opportunity under conditions that were not explicitly covered in Title VII.
When an employer sees my resume or my LinkedIn profile and they see that I have 20 or more years of experience, I think that's a signal of, oh, he's too old to work for us. And I am struggling financially, and I'm really scared. I'm really scared.
Under the ADEA, it's unlawful for any employer to refuse to hire, discharge, or to otherwise discriminate against any individual because of his or her age with respect to the individual's compensation, terms, conditions, or privileges of employment, or to limit, segregate, or classify employees in any way that would deprive an individual of employment opportunities or adversely affect his or her status as an employee because of such individual's age. Similar to Title VII, the ADEA also makes it unlawful for an employer to discriminate against any employee or applicant for employment because such individual has opposed any practice made unlawful by the ADEA, or because such individual has made a charge, testified, assisted, or participated in any manner in an investigation, proceeding, or litigation under the ADEA. The ADEA passed on the strength of congressional findings that the so-called older worker population had been denied equal employment opportunities owing to invalid stereotypes ascribed to workers of a certain age demographic. Since its inception, the ADEA has prohibited employment discrimination based on age, and that prohibition has always been limited to individuals in a defined age group. Initially, the ADEA solely protected individuals between 40 and 70. However, in 1986, the upper age cap was removed. The law does not protect workers under the age of 40, although some states have laws that protect younger workers from age discrimination. ADEA remedies include compensatory and punitive damages for employees, or damages if reinstatement is not feasible and/or employer's violation is intentional. The laws have evolved over the years and have been amended several times, including 1978, 1986, 1990, and 1996, thereby expanding the scope of the law and the protection afforded older workers. While the overall effect of the amendments has been to expand the law, court decisions have tightened the requirements for proving a violation. And according to the Equal Opportunity Commission, the EEOC, outdated assumptions about age in work persist as stereotypes and barriers to the employment of older workers. In 1996, the United States Supreme Court held that the ADEA prohibits discrimination against older employees in favor of younger employees when both are within the protected class of 40 years and older. In O'Connor v. Console Coin Caterers Corporation, the court reversed the lower court's dismissal of the plaintiff's claim that he was discriminated against because of his age of 56 when he was replaced by a 40-year-old. The lower court dismissed the claim because the plaintiff was not replaced by a younger employee outside the protected class, i.e., younger than 40. In reversing the lower court, the U.S. Supreme Court reasoned, the fact that one person in the protected class has lost out to another person in the protected class is thus irrelevant, so long as he has lost out because of his age. In 2004, the United States Supreme Court considered whether the ADEA prohibited discrimination based on age in general and held that it only prohibits discrimination against older employees. The ADEA does not bar an employer from favoring an older employee over a younger one. The year 2009 also marked the United States Supreme Court's decision in the case of Gross versus FBL Financial Services, in which it held that a plaintiff bringing an ADEA disparate treatment claim must prove by a preponderance of the evidence that age was the but-for cause of the challenged adverse employment action. In other words, but for his or her age, the plaintiff would not have experienced the adverse employment action. This decision distinguishes the burden of proof for an age discrimination claim from the burden of proof for a Title VII discrimination claim, the latter of which requires only that the plaintiff show that his or her race, sex, or other protected characteristic was a motivating factor in the employment decision. The court reasoned that because Congress failed to codify the motivating factor standard into the ADEA, as it did with Title VII, the court should presume that the omission was intentional. Critics argue that the higher standard of proof created by the court in Gross makes it too difficult for an employee to prove age discrimination, requiring that age be the sole reason for the discrimination, rather than a motivating factor. In her book, Betrayed: The Legalization of Age Discrimination in the Workplace, Judge Patricia Barnes criticizes the Gross decision and argues that age discrimination has effectively been legalized. Since the Gross decision, Congress has attempted on several occasions to pass a bill overturning Gross, but to date has had no success. There is no doubt that much has changed since the enactment of ADEA. The amendments to the ADEA have extended its scope and coverage, while the court has arguably made it more difficult for a worker to prove age discrimination. Whether Congress takes action to overturn the gross decision or to further expand the ADEA is yet to be seen. What we do know is that there is a greater number of older individuals in the workforce than ever before. People are healthier, living longer, and in many cases, wanting and needing to work longer than previous generations. Let us advance our timeline to 1972 and talk about the Equal Employment Opportunity Act, or the EEOA. This act reformed the Civil Rights Act of 1964 in historic ways. Specifically, it empowered the Equal Employment Opportunity Commission, or EEOC, to take enforcement action against individuals, employers, and labor unions who violated the employment provisions of the 1964 Civil Rights Act. And it expanded the jurisdiction of the Commission as well. That is to say, the 1964 Civil Rights Act was no longer a tiger without teeth. It now had enhanced enforcement actions. The EEOA reduced the number of employees needed to qualify for equal protection and increased the number of days employees could file claims. The year 2020 marked the 47th anniversary of the Rehabilitation Act of 1973, the predecessor of the Americans with Disabilities Act of 1990, the ADEA. While efforts to promote vocational rehabilitation services began in the early 20th century through the enactment of the Vocational Education Act of 1917 and the Soldiers' Rehabilitation Act of 1918, the Rehabilitation Act was a game changer in the pursuit of rights for individuals with disabilities in government, higher education, and private industry. After successive vetoes, President Richard M. Nixon signed the Rehabilitation Act into law on September 26, 1973. The Rehabilitation Act of 1973 was the first legislation to address the notion of equal access for individuals with disabilities through the removal of architectural, employment, and transportation barriers. It also created rights of persons with disabilities through affirmative action programs. In addition, the legislation attempted to address some of the societal barriers faced by individuals with disabilities, including isolation by placement in institutions, limited access to buildings, and discrimination in education and employment. Section 504 was modeled after Title VI of the Civil Rights Act of 1964. Specifically, it states, "No qualified individual with a disability in the United States shall be excluded from, denied the benefits of, or be subjected to discrimination under any program or activity that either receives federal financial assistance or is conducted by any executive agency of the United States Postal Service." Section 504 covers a college, university, or other post-secondary institution, or a public system of higher education, as well as other programs receiving federal funds. According to historians, Section 504 of the Rehabilitation Act was never discussed by Democrats or Republicans in debates leading to its enactment. Some speculate as to how the provision even made its way into the bill, with some believing that congressional staffers slipped the language in late in the approval process. It was the first time in history that rehabilitation legislation received no votes in Congress. The Rehabilitation Act served as a watershed moment in disability rights history. Most of its protections were eventually expanded to all organizations serving the public, regardless of whether they receive federal funds via the Americans with Disabilities Act of 1990. In 1978, Congress passed the Pregnancy Amendment Act, prohibiting sexual discrimination on the basis of pregnancy. The law amended Title VII of the 1964 Civil Rights Act to prohibit discrimination against pregnant women in any area of employment, including hiring, promotion, seniority rights, and job security. It also required employers who offered health insurance and temporary disability plans to provide coverage to women for pregnancy, childbirth, and related medical conditions. The bill was intended to reverse the 1976 Supreme Court decision, General Electric versus Gilbert, which held that employers were not required to include pregnancy in their disability pay plans. Section 7 of the Civil Rights Act of 1964 was therefore amended to add that to the term because of sex or on the basis of sex, included but was not limited to on the basis of pregnancy, childbirth, or related medical conditions. Note, therefore, that pregnancy discrimination claims fall under the category of sex-related claims and not disability. The act made it illegal for an employer to fire or refuse to hire a woman because she was pregnant. It required an employer to treat pregnancy the same way it would handle any other medically related condition or temporary disability of an employee. Company health insurance plans cannot exclude pregnancy. Also, employers are required to provide the same health coverage to spouses of male employees as they do spouses of female employees. The Americans with Disabilities Act, the ADEA, was signed into law on July 26, 1990 by President George H.W. Bush.
3 weeks ago, we celebrated our nation's Independence Day, and today we're here to rejoice in and celebrate another Independence Day, one that is long overdue. And with today's signing of the landmark Americans for Disabilities Act, every man, woman, and child with a disability can now pass through once closed doors into a bright new era of equality, independence, and freedom.
Its passage came after years of advocacy by disability rights supporters. In signing the Americans with Disabilities Act, President Bush declared that the ADA would ensure people with disabilities the opportunity to blend fully and equally into the rich mosaic of the American mainstream. The ADA is the most comprehensive of the nation's disability laws. It guarantees the rights of individuals with disabilities to receive reasonable accommodations to work and participate in all aspects of society. It prohibits disability discrimination. The ADA prohibits discrimination against what it terms a qualified person with a disability. The term disability means, with respect to an individual, a physical or mental impairment that substantially limits one or more major life activities of such individual, a record of such an impairment, or being regarded as having such an impairment. Major life activities include, but are not limited to, caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. Discrimination against qualified individuals with disabilities is prohibited by the Rehabilitation Act of 1973 and the Americans with Disabilities Act, the ADA, of 1990. The standards for determining whether the Rehabilitation Act has been violated are the same standards applied under the ADA of 1990. These standards are set forth in the EEOC's ADA regulations. Disability-based discrimination is arguably the most complicated area of employment discrimination and the most rapidly changing. The investigative approach differs based on whether the case is a reasonable accommodation or disparate treatment claim. This will be discussed further later in the course. On May 21st, 2008, the Genetic Information Non-Discrimination Act of 2008, the GINA or GINA, referred to by its sponsors as the first Civil Rights Act of the 21st century, was enacted and signed into law by President George W. Bush. It prohibits discrimination based on genetic information by health insurers and employers. The sequencing of the human genome and subsequent advances raise hope for genetic therapies to cure disease, but this scientific accomplishment is not without potential problems. An employer or health insurer could decide to take adverse action based on a genetic predisposition to disease, and situations have arisen where discriminatory action based on genetic information did occur. In addition, there is evidence that the fear of genetic discrimination has an adverse effect on those seeking genetic testing, as well as on participation in genetic research. This law was enacted to remedy this situation. The law is divided into two main parts: Title I, which prohibits discrimination based on genetic information by healthcare workers, and Title II, which prohibits discrimination in employment-based genetic information. Title III of GINA prohibits discrimination in employment because of genetic information and, with certain exceptions, prohibits an employer from requesting, requiring, or purchasing genetic information. The law prohibits the use of genetic information in employment decisions, including hiring, firing, job assignments, and promotions by employers, unions, employment agencies, and labor management training programs. The legal landscape of equal opportunity law is continuously changing. It is important for any professional in the field to stay abreast of changes in the law and the impact of such changes in the way we work.